Okay, let's paint a picture. It's January 8th, 2011, inside a prison in New South Wales. We're in a yard, and there's an offender, William Bugmy, on a telephone. He's agitated, and someone hears him make this really chilling threat. He's gonna split Gould open.
Right. Gould being one of the correctional officers.
Exactly. And just minutes later, some officers, including Assistant Superintendent Stephen Pitt and Officer John Donnelly, they come onto the wing. There's a confrontation.
And the threats escalate pretty quickly, don't they?
Oh, it do. It's not just talk. Bugmy suddenly runs, grabs these everyday objects, pool balls off a nearby table.
Turning them instantly into, well, dangerous weapons in that context.
Yeah. And he starts throwing them. He targets the officers. And one of those throws hits Officer Jason Gould right in the eye.
The impact was just devastating.
Yeah.
Officer Gould suffered really severe injuries. We're talking multiple complex surgeries over the next year.
Trying to save his sight.
Trying, yes.
Yeah.
But despite everything, his sight in that left eye, it just couldn't be saved. He lost it completely.
Oh.
His 11-year career was over. His whole life profoundly changed.
It's a horrific incident, obviously. And Officer Gould's life was, well, shattered, as he put it. But this single act of violence, it also kicked off this huge legal battle. A battle that went all the way through the Australian court system, right up to the High Court.
Yeah, and it forced this deep look at some really fundamental questions, didn't it? About crime, punishment, complex personal histories, and how our legal system actually tries to deliver justice.
Absolutely. So our deep dive today is into this landmark Australian case. Bugmy v. the Queen.
It's the story of that violent event, yes, but it's also, the story of the legal process itself, and how this really crucial principle about sentencing someone with a background of severe disadvantage was challenged and then ultimately clarified at the highest level.
We've really dug into the sources for this, the detailed judgments from the District Court, the NSW Court of Criminal Appeal, and the High Court itself.
Plus appeal transcripts, legal analysis, stuff that explains just how significant this case actually is.
Right. So our mission today is to guide you through this, high-stakes legal drama. We'll trace its journey through the courts. We'll highlight the key people involved, the judges, the lawyers at each stage.
And crucially, reveal its lasting impact, how it shaped Australian law, particularly how courts have to consider an offender's background, their disadvantage, when they're deciding on a sentence.
So by the end, you'll understand not just what happened, but why this decision, Bugmy, really matters for how justice works in Australia.
Exactly.
Okay, so let's start where it all began, the incident itself.
Right. January 8th, 2011. William Bugmy's on the phone in that NSW prison. He makes the threat against Officer Gould. Then, Assistant Superintendent Stephen Pitt and Officer John Donnelly approach him after the call. They ask about it.
And Bugmy gets aggressive.
Very. He challenges them, come on, you want a piece of me? I'll split you cunts. Really confronting stuff.
And that's when he makes a run for the pool table.
Yeah, grabs several pool balls.
And immediately starts throwing.
Immediately. Throws them at Pitt and Donnelly. One narrowly misses Pitt. But then he spots Officer Gould.
Ah, the officer he'd threatened earlier?
Exactly. He yells that threat again. You cunt, I told you I can split you open. He's targeting him specifically now.
And he throws again.
Throws two balls. They hit Gould in the back as Gould's trying to move away.
Okay.
But as Gould retreats further, Bugmy throws two more balls. And it's one of these later throws that strikes Officer Gould directly in his left eye socket.
Just horrific. And the consequences, you said catastrophic.
Yeah, the medical details are grim. Retinal detachment, fractures around the eye, socket, the orbit. Multiple major operations over the next year.
Wow.
Really complex stuff. Bone grafts from his hip, putting in a metal plate, just trying to reconstruct things.
But ultimately, the sight was gone.
Permanently lost.
Yeah.
And the pain didn't stop there. Ongoing pain, the prospect of future surgeries, not even for sight, but just to manage the pain or keep the eye itself viable.
Good grief.
Plus strain on his good eye, problems with depth perception, migraines. And that's just the physical.
The psychological toll must have been immense.
Huge. PTSD, anxiety, depression, sleeplessness. He needed significant psychiatric treatment. He lost that career he'd had for 11 years. Huge financial pressure on his family. His life, as he said, was just shattered.
Such a devastating outcome from one moment of violence. So what were the charges Bugmy faced?
Following the incident, he was charged with 2 counts of assaulting a corrective services officer while they were doing their duty. That's for the initial throws at Pitt and Donnelly.
Okay.
And then the really serious one, one count of causing grievous bodily harm with intent for that targeted, life-altering attack on Officer Gould. That carried a much heavier potential penalty.
Right. And those charges set the stage for the first round in court.
Which brings us to, let's call it Phase 1, sentencing in the district court.
So who is the judge and what happened there?
This took place before Acting Deputy Chief Judge Lerv, ADCJ, in the District Court of New South Wales. Bugmy actually pleaded guilty to all 3 charges. That was on May 17, 2011. His barrister was a Mr. Lawrence.
So, no trial on guilt. It moves straight to sentencing. What did Judge Lerv have to consider?
A lot. In his sentencing remarks, he noted that the main charge, the GBH with intent against Officer Gould, is what's called a result offense.
Meaning the seriousness depends on the actual harm caused?
Exactly. The worse the injury, the more serious the offense. He accepted there was no provocation and that Bugmy acted, quote, on the spur of the moment in a fit of anger.
Okay.
Now, Judge Lerv assessed the objective seriousness of that GBH offense as slightly less serious than the mid-range for crimes of that type. That specific assessment would come under scrutiny later on.
Interesting. What about things that made the crime more serious, aggravating factors?
Right, he definitely noted those. The victim, Officer Gould, was a correctional officer doing his job. That's a specific aggravating factor in the law.
Makes sense.
Also, the significant psychological injury caused, on top of the physical harm, and the use of the pool ball as a weapon, Judge Lerv saw that as comparable to using something like a knife or even a firearm in terms of dangerousness.
And Bugmy's own history, that came into play too.
Oh, yes. Bugmy had what the judge called a very poor criminal record, starting when he was just 13. Lots of assaults, property offenses, resisting police. He spent much of his adult life in custody. Judge Lerv took this history into account as another aggravating factor.
So quite a few things weighing against him. What about factors that might lessen the sentence? Mitigating factors?
Well, the judge considered Bugmy's very difficult background. He had been exposed to severe domestic violence as a child. His father had stabbed his mother.
Oh, wow.
History of drug and alcohol abuse from age 12, time in foster care, boys' homes, juvenile justice, then straight into adult prison. A really rough start to life.
And his mental health, was that considered?
Yes. Psychiatric reports were presented from a Dr. Bruce Westmore. They detailed a history of head injuries, possible brain damage, auditory hallucinations, though the cause was a bit unclear, maybe alcohol-related, maybe something else.
Okay.
He'd had psychotic symptoms back in 2009 needing psychiatric admission. Diagnoses included conduct disorder and substance abuse. Dr. Westmore also noted a risk of self-harm. Judge Lerv took these mental health issues into account.
And then there are the Fernando considerations, which often come up in cases involving Indigenous offenders with deprived backgrounds.
Exactly. Judge Lerv specifically accepted that these principles applied here. They come from a case called R.V. Fernando, and they basically recognize that severe social deprivation and disadvantage, which disproportionately affects many Indigenous Australians due to systemic issues in history, can reduce an offender's moral culpability.
How does that work in practice?
Well, it means the court should consider how that background might have contributed to the offending or limited the person's choices. Judge Lerv found these Fernando considerations operated very much in favor of finding special circumstances in Bugmy's case, despite his long record.
Okay.
And because of that, he actually reduced the weight he gave to general deterrence, the idea of sentencing, to discourage others in the community.
So he found special circumstances. What did that mean for the sentence?
He did find special circumstances, yes, largely due to the risk Bugmy faced of just becoming completely institutionalized after spending so much time inside, and also recognizing his great need for intensive rehabilitation.
So weighing all that up, the seriousness, the aggravating factors, the background, the mental health, Fernando principles, special circumstances, what was the final sentence from Judge Lerv?
For that main charge, the GBH with intent against Officer Gould, Judge Lerv imposed a sentence of imprisonment with a non-parole period of 4 years. The total sentence, or head sentence, was 6 years and 6 months.
4 years before he could apply for parole.
That's right. And this sentence was to start from November 2010, running partly alongside other sentences he was already serving.
Okay, so that was the outcome in the district court. But, as we know, that wasn't the end of it. The Crown, the prosecution, they weren't happy.
Not at all. They felt the sentence was too lenient, which leads us to Phase 2, the appeal to the NSW Court of Criminal Appeal, or the CCA.
What was the Crown's argument on appeal?
They appealed against that sentence for the GBH charge, arguing primarily that it was manifestly inadequate, just plainly too low.
Okay.
They also raised specific errors they said Judge Lerv made, like failing to properly account for the victim being a prison officer when assessing how serious the crime was.
Right, the objective seriousness point again.
Exactly. They also argued he'd made an error in how he treated Bugmy's mental illness, particularly in reducing general deterrence because of it.
How so?
They essentially argued the mental illness, as described, didn't lessen his self-control in a way that actually contributed to this specific offense, so it shouldn't reduce the need to deter others.
And the big one, the background, the Fernando factors.
Yes, this was a major ground. The Crown argued that Judge Lerv gave too much weight to Bugmy's deprived background, especially given his age and his extensive ongoing criminal history. They questioned whether that background should continue to carry the same weight over time.
Okay, so who heard this appeal?
It was heard by the NSW Court of Criminal Appeal. The judgment was delivered by Justice Hoban, and Justices Johnson and Schmidt agreed with him.
And what did the CCA decide? Did they agree with the Crown?
They did agree with the Crown on several key points. They found Judge Lerv had erred in assessing the objective seriousness.
Oh.
They felt he didn't give enough weight to the fact the victim was a correctional officer and the importance of general deterrence for attacks on prison staff, citing cases like Schneider's and Davis about protecting prison officers and maintaining order.
Okay, so error number 1 found. What about the mental illness argument?
They agreed with the Crown there, too. They found Judge Lerv had erred in reducing general deterrence based on the mental illness evidence presented. They basically said the illness described by Dr. Westmore had nothing to do with any aspect of the offending in a way that reduced his culpability or control for this crime. They called it an erroneous approach. To just assume a diagnosis automatically means deterrence is less relevant.
Right. And the crucial point about the background, the Fernando considerations.
This is where things get really interesting. The CCA acknowledged that Judge Lerv was entitled to take those factors into account. They weren't saying he was wrong to consider them.
Okay, but
their judgment included this really significant statement. They said that the relevance of social deprivation, quote, must diminish with the passage of time and continued offending.
so they're saying the longer someone offends, the less their bad background matters for sentencing.
That's essentially the principle they stated. And that statement would become the absolute core issue when the case went higher.
I can see why. Okay, so the CCA found errors. Did they then look at whether the original sentence was manifestly inadequate?
Well, this is where a critical procedural point comes in, one the High Court later focused on. The CCA actually said it was not necessary to deal with the manifest inadequacy ground because they'd already found these other specific errors.
So they skipped that step.
Effectively, yes. They said the errors they found meant resentencing was required anyway. And related to that, they made no mention of the residual discretion.
Remind us what that is again.
It's the power an appeal court has, even if it finds an error in the original sentence, to decide not to interfere if, all things considered, stepping in isn't warranted in the interests of justice. It's like a final safety check.
And the CCA didn't consider it.
There's no indication they did. They found errors and moved straight to resentencing. The High Court later saw bypassing these steps, not confirming manifest inadequacy first, and not considering the residual discretion as a fundamental flaw in their process.
Okay, so flawed process or not at that stage, what was the practical outcome? What new sentence did the CCA impose?
They allowed the Crown's appeal. They quashed Judge Lerv's original sentence for the GBH charge.
And replaced it with?
They imposed a new, tougher sentence. The non-parole period was increased from 4 years up to 5 years. The total term went up slightly too, I think to 7 years and 6 months. But the key change was that extra year before parole eligibility.
So a significant increase for Bugmy. But he didn't accept this outcome either, did he?
No. He decided to challenge the CCA's decision. He took his fight to the very top, the High Court of Australia.
Which brings us to Phase 3, the Apex Court, the High Court of Australia. And getting there isn't automatic, right? You need permission.
Exactly. You need what's called special leave to appeal. You have to persuade the High Court that your case involves an important question of law, or it's in the public interest for them to hear it. It's a high bar.
So Bugmy had to apply for this special leave first. Who heard that application?
The special leave application was heard by 3 High Court justices, Justice Hayne, Justice Bell, and Justice Gageler, on May 10th, 2013.
And who are the lawyers arguing the case at this point?
Bugmy's legal team was led by Mrs. D. Yahia S.C., a senior counsel, with Ms. G.A. Bashir as her junior counsel. They were instructed by the Aboriginal Legal Service.
A strong team. And for the Crown?
The Crown, representing the state of New South Wales, was represented by Mr. L.A. Babb, SC, instructed by the solicitor for public prosecutions.
Okay, so what were the arguments for Bugmy in trying to get special leave?
Ms. Yahia, for Bugmy, really hammered those procedural points we just discussed. She argued the CCA went wrong by not finding manifest inadequacy first before resentencing.
Right.
She argued the other specific errors the Crown raised were really just particulars supporting that main claim of inadequacy. And crucially, she argued the CCA failed to even consider its residual discretion.
Okay, the procedural fairness angle? What about the substance?
This was the other major thrust. Ms. Yahia argued forcefully that the CCA's statement, the one about the relevance of social deprivation diminishing over time, was just plain wrong as a matter of legal principle. She contended it was an erroneous principle of profound national importance, unsupported by existing law and potentially very damaging, particularly for Indigenous offenders. She traced its origins back through some, let's say, problematic lower court decisions.
So, a direct challenge to that core idea stated by the CCA. What did the Crown say in response?
Mr. Babb, for the Crown, interestingly, actually submitted that the original trial judge, Judge Lerv, had been correct to take the Fernando considerations into account.
Oh, that is interesting. So they weren't defending the CCA's diminishing relevance statement?
Not directly in the leave hearing, it seems. Their focus was more on arguing that Bugmy's points about residual discretion didn't really change things.
So what did the High Court panel decide? Did Bugmy get permission to appeal?
Yes, he did. And significantly, special leave was granted on all the grounds Bugmy had put forward.
Wow, all of them. That's a strong signal, isn't it?
It's a very strong signal. It showed the High Court saw serious, arguable issues across the board, both procedural and substantive, that warranted a full hearing by the entire court.
Okay, so special leave granted. Now we move to the main event, the full High Court hearing and the landmark judgment. Who sat on the bench for this?
The appeal was heard by a full bench of the High Court. Chief Justice French, Justice Hayne, Justice Crennan, Justice Kiefel, Justice Bell, and Justice Keene delivered a joint judgment. Justice Gagler wrote his own concurring reasons, agreeing with the outcome. The judgment came down on October 2, 2013.
And what were the High Court's main findings? Let's start with those procedural issues from the CCA appeal.
The High Court came down very clearly on this. They found the primary error by the NSW Court of Criminal Appeal was exactly what Ms. Hehe had argued: allowing the Crown appeal and imposing a new sentence without first determining if Judge Lerv's original sentence was manifestly inadequate.
So they confirmed that's a necessary first step for the Crown.
Absolutely. They stated that the power for an appeal court to substitute its own sentence is only triggered if manifest inadequacy, meaning the original sentence was unreasonable or plainly unjust, is established. And they agreed that the Crown's other arguments about specific errors were really just reasons why the sentence might be considered inadequate. They weren't separate gateways to resentencing.
And the residual discretion point.
They found the CCA's failure to consider its residual discretion compounded the error. They explicitly said this discretion must be considered in Crown appeals.
Right.
They even pointed to that concession the Crown prosecutor made at the original trial about mental illness, which the Crown then argued against on appeal. The High Court suggested that kind of change of position was exactly the sort of thing relevant to whether the CCA should have exercised its discretion not to intervene, even if they found an error.
So, major procedural corrections established. Now, the big one. What did the High Court say about social deprivation, disadvantage, and the Fernando principles? Did they agree with the CCA that its relevance diminishes?
Absolutely not. This was perhaps the most powerful part of the judgment. The High Court decisively rejected the CCA statement. They threw it out completely.
Wow. So what did they say instead?
They stated, very powerfully, and it's worth quoting part of it, "The experience of growing up in an environment surrounded by alcohol abuse and violence may leave its mark on a person throughout life. It is a feature of the person's makeup and remains relevant to the determination of the appropriate sentence, notwithstanding that the person has a long history of offending."
That is a landmark statement. So profound disadvantage is an enduring factor.
Exactly. It doesn't just fade away because someone gets older or keeps offending. The High Court affirmed that full weight must be given to an offender's deprived background in every single sentencing decision.
Full weight. But did they say that automatically means a lower sentence?
No, and this is the crucial balance. They cautioned that giving it full weight doesn't mean it has the same mitigatory effect for all purposes of punishment in every case.
What does that mean practically?
Well, for example, they said if someone's history of deprivation has unfortunately resulted in them being unable to control violent impulses, that very factor might actually heighten the need for community protection when the judge is sentencing.
I see. So it's not a get out of jail free card or some kind of special discount based on background.
Precisely. The High Court was very careful not to create a separate sentencing regime or race-based discount, even though these principles are particularly relevant for many Indigenous Australians.
Okay.
The principle they affirmed is race-neutral. Profound disadvantage, whatever its source, is an enduring factor relevant to assessing moral culpability. It has to be put into the balance with everything else: the seriousness of the crime, the need to protect the community, deterrence, rehabilitation, all of it.
They didn't adopt the Canadian Gladue principles then, which were mentioned in arguments.
They acknowledged the comparisons made in the hearing, but stressed the different statutory frameworks in Australia and Canada. They stuck to clarifying the existing Australian common law principles.
Okay. And just quickly, what did they say about the mental illness point?
They noted the CCA's finding of error there was perhaps less about the link between illness and crime and more about whether the diagnosis, as presented by Dr. Westmore, was a strong enough basis to reduce general deterrence. But again, they tied this back to the procedural failings and the unconsidered residual discretion, especially given the Crown's initial concession.
So after finding these significant errors by the CCA, what was the final order from the High Court regarding Bugmy's sentence?
The High Court allowed William Bugmy's appeal. They overturned the decision of the Court of Criminal Appeal, and they reinstated the original sentence imposed by Judge Lerv back in the district court.
So back to the 4-year non-parole period within the 6 years and 6 months total term.
Exactly. After that whole journey, the original sentence stood.
An incredible legal saga. So let's talk about the impact. What has Bugmy v. the Queen actually meant for Australian legal practice since 2013?
Oh, its impact has been really significant in several key ways. First, and probably foremost, it massively reinforced those Fernando principles. It provided the highest possible judicial authority for the principle that severe social deprivation is a potent and, crucially, enduring mitigating factor in sentencing. It killed off that idea that its relevance somehow fades away with time or more offending.
So it gives much stronger backing for defense lawyers making arguments based on background.
Absolutely. It significantly strengthened those arguments.
Yeah.
And while the principle applies to any offender experiencing that kind of deprivation, it's obviously particularly vital for Indigenous Australians, given the context of historical and ongoing systemic disadvantage.
Okay, that's the substantive impact on sentencing principles. What about the procedural side, the appeals?
Bugmy also really clarified the proper procedure for Crown appeals against sentence. It cemented the requirement that generally a finding of manifest inadequacy is necessary before an appeal court can step in and resentence.
Right, that first hurdle.
And it underlined that the residual discretion must be considered. Appeal courts can't just ignore it. This puts a brake, essentially, on too readily increasing sentences on appeal. It emphasizes caution.
So more hurdles for the Crown if they think a sentence is too low.
You could put it that way. Or more emphasis on respecting the sentencing judge's initial discretion unless it's clearly wrong.
And the third impact, something about individualized justice.
Yes, the decision really underscored the importance of genuinely considering the unique subjective circumstances of each offender. It pushed judges to look at the full context of their background, the lifelong impact of disadvantage, as part of that complex balancing act in sentencing.
Balancing it against
the objective seriousness of the crime, community protection, all the other sentencing factors. It encouraged, I think, a deeper, more informed approach to understanding how entrenched disadvantage might affect someone's moral culpability and what kind of sentence might actually be effective, considering things like rehabilitation, too.
So, to sum up, a shocking crime, a devastating impact on the victim, Officer Gould, leading to a legal journey right to the High Court. And that journey resulted in a landmark decision that clarified how Australia's legal system has to grapple with severe disadvantage. And it also tightened up the rules for when appeal courts can increase sentences.
That's a great summary. The key takeaways really are the enduring relevance of profound deprivation in sentencing, no matter the person's record, and the absolute necessity of procedural fairness when the state tries to argue a sentence was too lenient.
It really highlights the incredibly difficult job judges have, doesn't it? Trying to balance holding people accountable, keeping the community safe, but also acknowledging the complex, often tragic histories that shape individual lives.
It absolutely does. And it leaves us all, I think, with a really significant question to mull over.
Which is?
How can the justice system truly, effectively balance that need to punish serious crime and protect all of us with the undeniable, complex, often lifelong impact that profound social disadvantage has on the path an individual takes?
That is definitely a tough, ongoing question for our society and our legal system. And on that reflective note, that wraps up our deep dive into Bugmy v. the Queen.